A risk students don't see coming. Imagine this. You've come to the US on a student visa, full of dreams about your education and your future. But then, love happens. You meet someone, you marry, and suddenly you're asking yourself, can I turn my student visa into a green card through marriage? Thousands of international students face this exact question every year, and most don't realize how many traps lie ahead. If you're a student planning marriage or already married to a US citizen or permanent resident, this is the video you can't afford to miss. The conflict between student status and immigrant intent. When you enter the US on an F1 or other student visa, you're promising the government one thing, that you plan to study, not to immigrate. That's called non-immigrant intent. The moment you file for adjustment of status, you've declared immigrant intent, and technically your student visa is no longer valid. This shift doesn't automatically cancel your school record or stop you from attending classes, but under the law, you're no longer following the terms of your F1. That conflict can create complications you may not even see until later. The 90-day rule and timing your marriage. One of the most common mistakes students make is rushing into marriage or filing for adjustment too quickly after entry. Immigration officers apply what's known as the 90-day rule. If you marry or file for adjustment of status within 90 days of entering on a student visa, they may assume you had immigrant intent when you entered, which can be considered visa fraud. Waiting at least 90 days gives you a safer window to show that your intent truly changed after you were already here. Travel risks with pending adjustment. Travel is one of the riskiest parts of this process. If you file your I-485 and then try to leave the US with only your student visa, there's a very high chance you won't be allowed back in. Even if your F1 visa is still valid, border officers can see your pending green card application and cancel your visa at the airport. The only way to travel during this time is with advance parole, but even that carries risk. Re-entry is never guaranteed. The safest strategy is simple. Once you file for adjustment of status, stay in the US until your green card is approved. Employment, OPT, and the work permit problem. Students often ask if they can keep working on their OPT while their adjustment is pending. Technically, the moment you apply for a green card, you're no longer maintaining a valid F1, so your OPT authorization is no longer valid either. That means you could be working without authorization if you don't switch over to an EAD card. The good news is, adjustment applicants can file for an unrestricted work permit, but it may take months to arrive. In many cases, if you're married to a U.S. citizen, your green card may be approved before your EAD even arrives, solving the problem. Marrying a U.S. citizen versus a permanent resident. This is where strategy really matters. If you marry a U.S. citizen, you qualify as an immediate relative. That means you can usually file your I-130 and I-485 together, what's called a one-step adjustment. Even if you overstayed your visa or had periods of unauthorized employment, those issues are forgiven for immediate relatives of citizens. But if you marry a permanent resident, the rules are stricter. You may not be able to file both forms together, and you'll need to stay in valid non-immigrant status until a visa number becomes available. That could mean months of waiting, and if your F1 expires before then, you could be stuck. Why intent at entry matters. Customs and Border Protection officers can and do ask questions at the airport. If you re-enter the U.S. on a student visa while married to a U.S. citizen, and the officer believes you plan to stay permanently, they can deny you entry right there. That's why timing your marriage and adjustment carefully is critical. A cleaner path is to stay in the U.S., file for adjustment, and avoid risky international travel until your case is resolved. Real-life scenarios that go wrong. Let's look at an example. A student enters on an F1 visa in January. By March, they marry a U.S. citizen and file for adjustment of status. That's within 90 days, and USCIS could assume they lied at entry. Another student finishes OPT, keeps working, then files adjustment after marriage, but before their EAD is approved. Technically, that's unauthorized work. Both situations can be explained, but they add complications and delays to what could have been a straightforward case. A safer strategy for students considering marriage. If you're a student dating or engaged to a U.S. citizen, think about timing. The cleanest path is to remain in the US, avoid unnecessary travel, and wait at least 90 days after your most recent entry before filing. Apply for adjustment with both the I-485 and the I-765 for work authorization. Don't rely on your student visa after filing. And if your partner is a permanent resident, understand that you may face a waiting period before you can even submit the I-485. Additional complications with immigration history. For some students, the problem isn't just timing, it's history. If you entered the U.S. as a child and were ever listed on your parents' asylum case, or if there were old removal orders you don't know about, filing for adjustment can trigger unexpected consequences. A Freedom of Information Act request to check your record is smart before filing, especially if your family had prior cases. Finding out at the green card interview is the worst time to discover hidden issues. Why students must avoid common myths. A lot of student visa holders think they can maintain their F1 while their adjustment is pending as a safety net. That's not true. The law says the moment you declare immigrant intent, your F1 no longer. Others believe travel with a student visa is safe until the green card is approved. Again, not true. These myths lead to mistakes that cause denials and even removal proceedings. The truth is, once you shift your path from student to immigrant, you must play by a completely different set of rules. When you look at all of this, it's clear that adjusting status as a student through marriage can be smooth, but only if you understand the hidden risks. Filing too soon, traveling at the wrong time, or relying on outdated advice can turn an exciting new chapter into a legal nightmare. Students who plan carefully, avoid unnecessary travel, and get professional guidance before filing usually succeed without issue. Financial sponsorship considerations. Affidavit of support, Form I-864. Every marriage-based green card requires the U.S. citizen or permanent resident spouse to prove they can financially support the immigrant spouse. Minimum income requirement. The sponsoring spouse must meet a certain income level, 125% of the federal poverty guidelines. Challenges for students. If the U.S. partner is still in school or early in their career, their income may not meet the requirement. Joint sponsor option. In this case, a parent, relative, or household member can serve as a joint sponsor, using their income or assets to help meet the threshold. Common mistake. Many couples overlook this requirement, leading to delays or even denials, not because of immigration issues, but purely financial documentation problems. Alright guys, that brings us to the end of today's breakdown. If this video helped you understand the risks and strategies of moving from a student visa to a green card through marriage, make sure you take these lessons seriously. Once you apply for adjustment of status, the rules change and mistakes can follow you for years. If this video helped you, hit like, share it with someone who needs it, and drop your experience in the comments. And don't forget, subscribe to Visa Intel USA for the latest immigration updates that actually matter. Thanks for watching and see you in the next video.